Stay home, me stay. Me pese me coaching.
You are welcome once again to Xtel TV. Thanks for following us. Thanks for sticking and staying. We promised you an exciting content this year, and we are delivering as we promised. Today, we'll be interacting with a law. Is it a lawmaker, a law person? We'll be talking about the laws of a land. It's going to be eye-opening and educative, especially for workers and those of us who don't know much about the labor law in Ghana. Before we start our interaction, let's quickly acknowledge our sponsors. Searchlight Africa Unisex Salon and Boutique, which is located in Tantra Hills beside the Ghana Commercial Bank. Lenavo Foods Pintex, Asafo Exotic Products, Fabio Cash, Viva Yogo, King Cold Properties. And for our Say It Right segment, let's look at these two sentences. Can I lend your umbrella? Can I borrow your umbrella? Can I lend your umbrella? Can I borrow your umbrella? We'll get the answer after our interaction. Stay with us. With me today is Mr. Stephen Osei-Kissi. He's an old student of Presec Legon. He's another year, my second school. And he holds a master's degree from the University of Ghana Law School in ADR. He is the head Greater Accra Regional Secretariat, National Labour Commission. Thank you very much for coming on Xtel TV.
Thank you very much, madam.
It's an honor, and we are so happy you agreed to be on this show to educate our audience and let them know the laws of the land.
Yeah, it's been a long time coming. I believe that we've discussed this over some weeks now. I think that getting you and getting me on one good day has been difficult, but well, at least today we have today, so we'll make the best of it.
We'll make the best of it. Okay, so for the benefit of those who don't know anything about Labour Commission, can you give us a brief history of the Labour Commission?
Okay, so the commission was set up about 14, 15 years ago. Now, its creation is, you would say that it's a creature of law. Now, when we say something is a creature of law, it is established because of the passage of a certain law. So with the passage of the labor law in 2003, a part of that law gives the provision for the establishment of the National Labour Commission. So following the passage of the law, and then when President Kufuor put his signature to it, and then it became proper law in Ghana, the Labour Commission was set up. Now, between 2005 till date, we have received something in the region of about 1 million plus cases. And all of these cases we have received are labor-related cases. We don't do civil or criminal cases. Our main goal is the resolution of disputes at the workplace. So any dispute at all, whether it's an unfair labor practice, any form of discrimination at work, redundancy, any issue bordering on your employment, if there are issues you want to be resolved, then you come to the Labour Commission. So in brief, that is what the Labour Commission is about. Okay,
Mr. Stephen, what are the labor laws in Ghana?
Okay, when it comes to the laws regulating labor, there is the Labour Act, which was passed in 2003, which is also called Act 651. Okay. Now, accompanying the labor law is two legislative instruments. These LIs are more or less regulations that govern how, one, the commission is supposed to work, and then two, how the various forms of dispute resolution mechanisms are supposed to operate. So labor laws in Ghana is the Labor Act, the LIs that accompany the Labor Act, and then there's also the passage of the ADR Act.
You see, for the benefit of those who don't really know much or can't explain the terms, what is the ADR? What is the LI you mentioned?
Okay, so the LI is simply a legislative instrument. Okay. And it always comes with a law. So that we pass the law, we pass also a legislative instrument that guides how the law is supposed to operate. Now, the ADR Act is the Alternative Dispute Resolution Act, which was passed in 2010. Now, it gives us various alternative ways of resolving disputes. Now, those disputes are not only labor-related. When it comes to the ADR Act, it has a wide scope which it operates within. But if you come into the realm of the labor law, it is strictly on labor. So in the conduct of our work here at the Labor Commission, our main working law is the labor law, the two LIs, as I've already mentioned. There are two LIs. There's the LI 1822, and then there's the LI 1833. The numbers are the number as at the time that the law was being passed. So don't get twisted don't get confused with the numbers. So those three, and then we are also guided by the Workmen's Compensation Act, and then the SNIT Act. All of that govern how we work. However, if we have to decide on SNIT issues, we'll refer the matter to SNIT to deal with because it is within their jurisdiction. Yes, so if it is in Ghana, our labor laws are just the Labor Act, and then the two LIs that come with it, and then you can add the ADR Act as well.
Okay, so are these old laws or they are new laws? Do the laws change as we progress, as we move?
Okay, since 2003, when the labor law was passed, we are yet to have a review of the labor law. The ADR Act is pretty current. I think it's just about 11 years, because that was passed in 2010. So that one is a pretty young law compared to the labor law. Now, as and when we grow as a nation, there's the hope that at some point, some parts of the law, when I say the law, the Labor Act, would see some review. That hasn't come up yet, but I am sure that when it is due, the stakeholders or the social partners will look at where they think we have to make the amendments, and then those amendments can be made. However, as we progress as a nation, what we've done is to add on to what is already existing. So we realize that there's a new law that has been passed for domestic workers. So that if I get up and say, I'm going to my village to go and bring Ama Boatma to come and stay with me as a help, the new law is saying that I am supposed to give Ama Boatma a letter. After agreeing with her parents or my uncle that I am taking her to Accra, we should have an agreement on how I am going to treat Ama when I bring her to Accra, and what she is going to earn as whatever role she's going to play in my house. And when I bring her, she's entitled to Social Security. So these things were not there before. But with the passage of that law, then it means that even domestic workers are given some proper, you'd say, acknowledgement by the law. Yes.
So talking about a document like a paper, what particulars should it be a must? What particulars should reflect in such contracts?
Okay, so if it comes to employment contracts, if you pick the labor law at Schedule 1, you would have some formats which the law provides for everybody to use. Now, you can improve on what is in the law, but you can't make it worse than what has already been provided. So when you pick the Schedule 1, you would have the name of the employer, the name of the employee, the position, salary, statutory deductions. There's also notice on termination, disciplinary procedure, and then the signature slot for the employee, and then the employer who is handing out the employment contract. Okay. Yes.
So what does the law say about working hours and leave? Okay.
Working hours, ideally, you are supposed to, in Ghana, you're supposed to work 8 hours a day, 40 hours a week. Now, it is up to your employer to schedule how these hours are going to work. That is why you will find that in some places, people run shifts. In some places like where I am now, we don't do shifts, so that you come in the morning at 8, you close at 5, Monday to Friday. Somebody else will do 8, close at 2, Monday, Tuesday, Wednesday, the person is off. You continue on Thursday, Friday, Saturday you come, Sunday you come, Monday, Tuesday you are off. In all, when we are summing up those hours when you run a shift system, it should meet the requirement of law, which is 8 hours a day, 40 hours a week.
Okay, so you said these laws protect even domestic workers. Do this law also apply in the church? Does it protect church workers?
A worker is a worker, whether you are working in my uncle's house, or you are working in a church, or you are working for a priest, or an okonfo, wherever you find yourself, so long as we can establish an employment relationship, the labor law comes in. So you would find that, earlier you mentioned number of hours of work and then leave. The law says for every worker. It didn't say for workers of Xtel TV or Labor Commission or Bank of Ghana. Yeah. It says for every worker, you have a minimum of 15 working days to enjoy as leave. So for an employer, I can decide that I'll give you the minimum requirement of law, the 15 working days. Some people can give you 18, 20, 25. It goes even way up to like 30, 35 days. And it's working days. And in law, when we say working days, the weekends are not parts. For those of us who do a Monday to Friday job, when we are talking about the working days, it is Monday to Friday, not the weekends. So if it is 15 working days, you would realize that it is something close to like a month if you're going to. And it is not 3 weeks. People confuse it and say 3 weeks, but no, it is 15 working days.
Okay. Yes. So have you got the opportunity to sit on a case between a pastor and his church worker or workers?
Yeah, we've had complaints from church. And just like a non-church organization, you would also find that our churches are not informed of what our labor laws even require of them. So we assume, oye nyame adwuma. But then again, onyame adwuma na oye no doesn't also mean that whatever rights the law accrues to you should go away. So you'd find that the person is a church security. He hasn't gone on leave before. When he is sick, he goes to the hospital. They say, because you didn't come, we will take it from your salary. When he brings an excuse duty, they say, no, we will not accept it because you are supposed to be at work. No. That you run a church, that you have employed people, it means that all of the rights, all of the duties that have been put in law, I mean the Labor Act, it applies to you. The Labor Act is not bothered whether you are a church or you are an NGO. Once you bring in somebody and you are paying for the person's service, then you should know that that person is covered by law. And the law puts a certain duty on you as the employer, whether you're a private organization, a public organization, a church, a mosque, to respect these rights and carry out those duties as well.
What are the rights of a worker?
Okay. If you pick our labor law, section 10 talks about the rights of a worker. 11 talks about the duties of a worker. They are a lot. So permit me to just pick it from what the law is saying directly. So now, if you look at section 10, it talks about the rights of the worker. It sets out 5 rights. Now, these are not, you can add to as an employer, but what the law is saying is that for every Ghanaian worker, you have the right of 1, to work under satisfactory, safe, and healthy conditions. Number 2, to receive equal pay for equal work without distinction of any kind. So it is immaterial whether you are a man or a woman. If you are a woman and you are working in a man's job, you get paid like a man will get paid, no distinction. 3, to have rest, leisure, and reasonable limitation of working hours and period of holidays with pay as well as remuneration for public holidays. Number 4, to form or join a trade union, because that comes as an inherent right, because even the Constitution allows that you have the freedom of association. So you decide to either form or join a trade union. And then to be trained and retrained for the development of your skill. And then the last one, to receive information relevant to your work. So if you are an employer, the law is saying that it is the worker's right to receive information relevant to their work. So if you bring the person in and you don't tell the person, here, we don't drink on the job, we don't smoke on the job, we don't fight on the job, and then the person does that, and you say you have violated the work rule, then it means that you have violated this very basic right of letting the employee know information that is relevant to his work. Now, if you go to the duties, it is also pretty elaborate. The first is that you are to work conscientiously in the lawfully chosen occupation as a worker. Number 2, to report for work regularly and punctually. So it's not just about going to work. The law is saying that you have a duty to report regularly and also to be punctual as well. It also says that you have the duty to enhance productivity. So you don't come at 9, take permission at 11 to go to the market or somewhere else, go to the bank, come back at 3 and close at 5. Then it means that you are not enhancing productivity in any way. It also says that you are to exercise due care in the execution of your assigned work. Obey lawful instructions regarding the organization and the execution of your work. To take all reasonable care for the safety of your fellow workers. And then to protect the interest of the employer. And lastly, to take proper care of any property that will be entrusted in your care. So 10:11 talks about the rights and then the duties of a Ghanaian worker. Yes.
Okay, these ones are so clear, the rights and the duties of a Ghanaian worker. So can we talk about the regulations for the security of a Ghanaian? Yes.
Now, if we come to the security people, and unless I'm not getting your question right, but if it comes to police, military folks, they don't come under the labor law. But if we're talking about provisions that secure a worker's...
Yes, employment security.
Okay, then you'd have regulations or provisions like leave, sick leave. You know, leave is not... Leave, there are various classes. There's the general leave that you get. And then under that, there's sick leave, there's compassionate leave, there's maternity leave. So all of these come together to protect or secure a worker. There's also the disciplinary process. There's also a grievance procedure. There's also a dispute resolution mechanism as well. So that all of these things come together and then they inform how you are protected once you call yourself a worker. And then when there are issues, how those issues are to be addressed. All of these come together to more or less secure your stay for, depending on how long you decide to be there, unless maybe you do something and you are sacked. Then it means that all of these things inform how you're treated at the workplace.
Okay, and what's the compassionate leave, and how long do women go for maternity leave?
Okay, when compassionate leave, usually it's given when you suffer a loss. So maybe you've lost a parent or a sibling or a partner or a child. Then you are granted, and usually it is industry specific. Some organizations will give you 5 days, somebody will give you 10 days, but you'd find that it is not so many days. It is usually to give you time to accept the loss, process it, and then put you in a proper frame of mind to return to work. So that, I remember last year when I lost my dad, I think I was given 5 days off work. The weekend it happened for 1 week. I was not present at work, just to give you the chance to, soak in, reflect, and then you come back as a proper person again. So that's about sick leave. About compassionate leave. Sick leave, when you go to the hospital and the doctor says, take these days off, they give you a medical excuse duty, so you can be given sick leave based on the medical excuse duty. When it comes to maternity, the law says that 12 weeks for a nursing mother from the date of birth, 12 weeks, not 3 months, 12 weeks. So when you calculate, 12 weeks will put you beyond 3 months. So most of the time people say, oh, go on 3 months maternity leave. The law is saying 12 weeks. It is specific. Now, if you have a twin, if you give birth to a twin, you get 2 extra weeks for the nursing mother. So that if you get twins, that's 14 weeks. If you just a single birth, 12 weeks. Yes.
So I smiled when you said you were given 5 days off when you lost your dad. So what happens to a worker who works with the Labor Commission and this right is infringed on?
It won't happen.
How do you guys settle such issues here?
You see, we are in Ghana. We pride ourselves to be a cultured society. So there are certain respects we accord each other when certain events take place in our lives. So if I have lost my dad and I call my HR and say, Madam, this is what has happened to me. It's death. This is Ghana. We like funerals. Okay. You let us know. And when we say let us know, that is more or less to officially inform. Because sometimes we assume the phone calls alone. In some places, the phone call is enough. But when you call and they say, let us know as an entity, then it means that they're asking you to write so that it can be placed on record. So those days cannot be deemed as days that you have absented yourself from work without permission. So you inform that this is what has happened. Then you are granted those days to just ease off a little, and then you come back. But it is up to an employer to institute some of these things. In some places, this is not there. But informally, they may give you a day or two to just ease up a little, and then you return to work.
This is deep. This is clear. We understand. So, but what does the law say about work and wages?
Well, I'm sure that you heard me read. It says that for an employer, you're supposed to pay at the agreed time and date.
So what's the minimum wage in Ghana?
I think currently it's about 11 cedis and 80-something pesos. If you convert it to dollar, you will cry. So let's keep it with cedis. So that is hopefully this year, they are still negotiating, and this is done by the National Tripartite Committee. So they meet on a yearly basis, not just to discuss the minimum wage, but to discuss other work-related policies as well. But for Ghana, we know the Tripartite Committee just on minimum wage negotiations. So it is still ongoing. I think yesterday they even met, or today they are supposed to meet. So as and when they're able to conclude the negotiations, we're hoping, and it's the wish of every Ghanaian worker, that the minimum wage would go up a little, so that at least we can have some fair salary to meet the present times that we find ourselves in. Yeah.
Okay, so a follow-up. When you were making your submission initially, you mentioned termination. So I want to know, on what grounds is it legal to terminate an employee's contract?
Okay. Now, our labor laws say that a termination would be fair if it is based on mutual agreement by the parties, that the employer and the employee decide that, okay, at this point, we should part ways. The law will not question that agreement, or it is done according to a fair procedure or by the provisions of the labor law. So these things are there to guide employers and employees so that you don't just get up and say, I don't like the look on your face, so go home. Our laws say that you are supposed to have the grounds to terminate. And those grounds, you would find it under the section 15. Those grounds are there. It could be poor performance, it could be ill health, it could be as a result of sexual harassment, and some other issues, proven misconduct, all of those. Once you have those grounds, then the law is saying that if the person has worked for more than 3 years, you give the person 1 month notice or 1 month salary in lieu of the notice. So the grounds that you have to stand on should be grounds that you can prove, or you have proof to show that truly the worker is not performing. So that if it is, the termination is based on performance, you have done some appraisals, you have done some performance improvement programs, all of those things have been done, and yet there is no improvement. On that score, when you terminate, the appraisals will speak for themselves. So it will make, what we would say, it will make it a clean termination. But if the ground is not there, and you say, well, when I gave you the letter, I said that if I want to terminate, I will give you 1 month salary or 1 month notice. So I am giving you the 1 month salary, stop work. But you don't assign the reason for the termination. Then the person can walk into our office and say, they sacked me, they didn't tell me why. So please, hear my case for me. And there would be legitimate causes to process that complaint and have the situation heard, and then some remedy given.
Okay, so the minimum notice for termination is a month, like you said?
Yes, if you have done 3 years or more by law. If you have done less than 3 years, it is 2 weeks. However, if the appointment you were given, it gives you notice that is higher than what the law provides, then it is what is in your appointment that will prevail, because those conditions are better. But if it is less than what the law provides, then the law would take precedence over what is in your contract.
Okay, so what should the worker do if they are not terminated properly or fairly?
Well, for most of the time, it will be a little difficult for you to unilaterally determine that you have been unfairly terminated. Like I said, if you have been taken through a certain procedure before the termination has taken place, it will be difficult unless there are issues bordering on the process that was used to terminate you. But if that is not present, then it will be difficult to say, I have been unfairly terminated. That is something that is determined by the Labor Commission, that this action is unfair based on X, Y, and Z, because those provisions are clear in law.
Okay. So let's talk about resignation. Should a worker also give notice before resigning?
The notice goes both ways. So the worker, you are enjoined to give notice, same as the employer. So if I decide to terminate, or if I decide to end my appointment with the commission, I am bound by the terms of my contract to give them a month's notice. Okay. Or pay 1 month's salary to the commission, then I go.
Okay, and is a worker entitled to pay?
When you resign?
Yes.
When you resign, you get paid for the period that you worked, because you have chosen to resign. However, if in the employment there are certain conditions that come to you, whether you resign or you are terminated, then away from giving the proper notice, those other payments are also made available to you, like Provident Fund or a welfare scheme.
Great. So I read something, you see, when I was coming on my way, I decided to read something on the labor law, and there was something in Act 651. It says an employer shall not make any deduction by way of discounts, interests. Yes. What are the permitted legal disciplinary action that can be taken against a worker, aside deducting money? Because this is the norm. This is what we know. This is what employers usually do against their employees. Is it right or not to deduct a worker's salary? And I would want you to tell us some of the disciplinary actions that can be taken against a worker should they be found doing anything wrong against the company.
Okay, I'll start from the last statement and then I'll work my way forward. Now, the labor law as you have it gives an employer the right to set out policies and programs on how they intend to run their organization. So it means that it is on the employer to put out disciplinary measures to make sure that certain actions that they deem to be improper are not seen at the workplace. So if you don't do that, then it means that you as the employer have slept on that right that the law has given you. Now, you'd find, like you said, you find that somebody will say, you didn't come to work, so I am deducting it from your salary. When you pick our labor laws, there is nothing in the labor law that says if a worker is absent or late, you should deduct from their salary, unless the worker works is marked by day. So that if I do a by day job, I am a mason on a project, I get paid as and when I come and carry mortar or do some plastering. If I don't come, I don't get paid. But if I am recognized as a salary earning worker, there is nowhere in the law that says if I am absent, I should lose my wage for that day. The law is saying that as an employer, have policies and programs to correct absenteeism. But that correction should not affect the person's salary. And it's something we receive here a lot, that the person will come and say, oh, I didn't go to work 3 days, they deducted it. I was late, they deducted. And sometimes the deductions are pretty huge. Somebody doesn't go to work one day, they deduct 80 cedis, 100 cedis. What is the minimum wage?
Exactly. Yeah,
so if it is, even if the minimum wage is less than 12 cedis, so if somebody is absent and you are deducting times 5 times 8 of the minimum wage, that is not proper. Mm-hmm. Again, if you look at section 70 of our laws, it spells out what the law recognizes as permitted deductions. And with your permission, I'll just quickly run you through them. The first is any amount due from the worker in respect of contributions to any provident, pension, or other fund or scheme agreed to by the worker. Any financial facility advanced by the employer to the worker at the written request of the worker, or any facility guaranteed by the employer to the worker. Any amount paid to the worker in error as remuneration in excess of what the worker is ideally expected to receive. Then it goes on to say, on the written authority of the worker, any amount due from the worker as membership fee or contribution to an organization for which the worker is a member. So somebody will say, oh, every month, deduct 10% and pay to my church as tithe. He has written, so you are permitted to do those deductions. Or maybe he belongs to a professional group or a tennis club, those kind of things. They will write and say, deduct and pay to the entity.
Okay, so salary forms part of the agreements in a contract, and the pandemic has fundamentally affected both employees and employers. And in some instances or in some institutions like a school, the workers are either laid off permanently, like the security, the cleaners, and all of these people. What happens to them? How does the law protect these people? Because this COVID itself, we didn't see it coming. It just affected the whole world. How does the law protect these workers? You know, it has affected both the workers and the employers. Both ways suffers, but the workers suffer more because they have to be laid off completely. How does the law protect or help them?
Okay, you see, nobody envisaged COVID to come. So you would find that our laws don't have a specific provision on how to address job losses as a result of COVID. So you realize that from all of last year and even presently, it's not all of the institutions that are fully recovered. People are now putting the pieces together. So for persons who have lost their jobs, especially during the hot period of COVID, for those complaints that we received, it was more of looking at the present circumstance and agreeing on something from both sides to resolve the matter. Because the circumstances that would lead to, or that led to the job loss, is not something that any of the parties envisaged to occur. So when it happens, we encourage parties that, look, this is difficult for everybody. So ideally, maybe by their conditions, maybe you may be raking something, maybe like a 2-month salary for every year you have worked, or 1 month for every year, or a number of weeks for every year you have worked. But COVID may not give you, or will not be able to bring in that circumstance. So therefore, you realize that maybe instead of doing like 3 months for every year, or 4 months, or 2 weeks for every year, there could be like a flat payment, maybe like some 5-month salary across the board, so that everybody gets something small to cushion, because the losses is on everybody. If I'm an employer, it means that my investment has suffered. And those losses, I cannot tell my employees that pay for it. So in like manner, the employee who has lost the job as a result of COVID should also recognize that it is not the doing of my employer. So if we agree that on any given day, I am supposed to give you so much, and because of COVID, I can't give you that, then it is only fair that both parties look at what is reasonable, and then it resolves the matter. We usually, COVID-related cases, we don't settle them by provision of law, because you won't find anywhere that says when it gets that bad and there's a pandemic and X and Y and Z and people have to go pay X, Y, and Z. You won't find it anywhere in any law. Maybe when we are looking at amending the labor law, we'll look at something that may look like COVID, so that if it happens, then we introduce provisions to cater for the investment of an employer and also to protect the interest of a worker.
So far, have you had issues or cases coming like this?
We have. Last year was pretty horrible for us as a commission, because post-COVID, when we relaxed a little so that the system can start running again, I think that 60% of the cases we received in 2 months were COVID-related job losses or issues bordering on COVID. So yes, it's been difficult for us as a commission, but I think that between that time and now, we've been able to ride that storm, and now what we receive it's barely about COVID. Just a few. Maybe and for those that are COVID related, it's with the hospitality industry, because it hits them pretty worse. So they are now finding their feet again. So yes, once in a while we get COVID-related job loss case. But beyond, I think we're in May now. I think that from like October, all of it is not about COVID. Yeah, pardon me, I want my issues resolved, those kind of situations.
Okay. So I'm taking us back a bit. Okay, so I worked with an organization before, like years back, and my boss deducted some salaries from me. I've left. It's past 5 years. Can I fight for my money, that money that was deducted?
If it's beyond 6 years, then you are limited by law. There's something we call the Limitations Act, so that if it is not criminal, then within 6 years you are expected to take action on that. After 6 years, then you are limited by law to pursue.
Okay, and within these 6 years, if I'm able to pursue this money, will there be interest on it, or is it the same amount of money?
Well, it would depend on where you go for the settlement, so that if it is at the commission would decide if interest should be awarded on the sum or not. If it is court, as for court, I can tell you 100%, they will say pay interest on the sum, because it is not something you should have deducted in the first place. So if you have deducted, then it means that in the minds of the court, you may have worked with that sum and may have made some money off it. So whatever you made off it, you pay in addition to whatever it is that you deducted.
Okay, so we are really, really far behind time, and there's a lot. I have lots and lots of questions for you, but time would not permit us. Would maybe have to come back for a part 2. But before we leave, can you take us through how you solve cases in the Labor Commission? How is your arbitration process done? And you mentioned court. Are there instances where you refer or you transfer cases to the court?
Okay. So we go to court when we want to enforce our decision. So that we decide on a matter. If one party fails to comply, then we go to the court for enforcement. That is the only time we'll go to the court. Or somebody is not happy with our decision, so they appeal against it. Then we'll have to go to the appeals court and go and defend our decision before the court. Now, away from that, when you come to the Labor Commission, there are 4 dispute resolution mechanisms that we use. The first, which is mostly the beginning, is facilitation. Then we have mediation, we have voluntary, we have compulsory arbitration, and then there is summary settlement. So as and when the dispute graduates, you move from one level to another. But you would find that for like 60% of the time, most of the cases end from the very first beginning, facilitation. We settle on them something, we agree, we put it on paper, we sign it off, and then we are done.
Okay, so I bring a case to the Labor Commission on 1st May. How long does it take for us to finish settling this issue? Does it take a month, 2 months? You know, sometimes you take cases to the court and it takes years. Is it faster with the Labor Commission?
I believe that it's faster with the Labor Commission because when you bring in a complaint, if you bring it today, in 3 days, we are supposed to process it and serve the party you have the complaint against. Now, when we do, that party has 14 working days to respond to your complaint. If within the 14 working days we don't get a response, we send a final reminder of 7 days to respond.
And that makes 3 weeks.
So, no, 14 working days. It is not 3 weeks.
Okay.
So, if we get within the 14 working days, praise the Lord. If it doesn't come, then it means we'd have to do a final 7-day notice to the other party. Now, once we receive the response from the other side, we convene a meeting, bring the parties together, and then we begin the dispute resolution process. So we begin with facilitation. Now, if you get the cooperation from both sides, maximum 2 months, because of the processing, the serving, scheduling of the meeting, maximum 2 months. If both parties are cooperative, the matter ends. If the parties are entrenched in their position, then you can run for years at the commission because then it means we would graduate you from one level of dispute resolution to another level till the final level where a decision is made, and if you are not happy, then you go to court and go and appeal against it.
Okay, and is it free to engage the services of the commission?
The commission's services are free. The only time you will pay for a service from the commission is when you do mediation and voluntary arbitration, because those are done by persons who are not staff of the commission. So you have to pay them.
Who are these people?
These are, the law requires the commission to keep a database of qualified mediators and arbitrators. Okay. And these are persons who have gone to school and learned the trade. Okay. So clearly, they would have to receive some service for the trade. So when you have an issue and we refer it to mediation or voluntary arbitration, know that it is coming with costs. But all of the processes leading to is free. Okay. Yes.
And where you have to pay, is it affordable for an ordinary Ghanaian like me?
I believe it is.
Okay. So kindly tell us about your branches. Where can we find the Labour Commission across Ghana? Okay.
So we are in Kumasi, Ahunjo to be precise. Okay. And then we are in the Western region as well. I don't know if it's still Western region or... but I know we are in Takrady. And then we are also in Accra. Now in Accra, we have 2 offices. There's the head office, which is adjacent the Ridge Hospital. And then there's the Greater Accra Regional Office, which is here in Tema, Community 10. We are in the Mayflower House.
Okay. So it means we don't really have much branches in Ghana?
No. Because we are a fully government-subvented institution. As and when government says, I have money, go and open a regional office, then we do. If the money is not there, then we manage with what we have.
But do we have enough education informing people, telling them there's an institution like this where workers can run to or employers can run to in case they have issues?
I think on the average, maybe 4 out of every 10 persons know. So there is the need for us to go out there more so that people will know we exist. But going out there is not cheap. So because we are handicapped financially, you don't see us making so many adverts that, oh, if you have an issue, come to us. But really, that is the challenge. It is the finance.
For our Say It Right questions, we had, can I lend your umbrella? Can I borrow your umbrella? Can I lend your umbrella? Can I borrow your umbrella? The right answer is, can I borrow your umbrella? Never say, can I lend your umbrella? It is, can I borrow your umbrella? Thank you very much for staying with us on Xtel TV. Catch you on our next episode. See ya.
Stay home, me stay. Me pese me coaching.